Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this discussion. This is a special bulletin to share with you the recent en banc decision known as Nunes versus the Department of Motor Vehicles. And this is an en banc decision that came down through the WCAB on June 22nd, 2023. So that gives you some idea as to the timing of this recording. This recording is being made immediately after this decision. And you'll recall, if you were paying attention during this time period, this case created quite a buzz because it's one of the recent en banc decisions to come down through the WCAB. And anytime that happens, of course, there's a big buzz and a big stir, as the WCAB takes the opportunity to create a precedent and to educate not only all of us in the medical legal community, but also all of the courts, all of the judges. These WCAB en banc decisions become binding precedent on all the judges and all the courts throughout the state of California. So these en banc decisions are a big deal. Now, as far as qualified medical evaluators are concerned, this particular decision has only a few teaching points for qualified medical evaluators, because the bulk of the conclusions related to this particular decision are independent of the work that we do, but they're tangentially associated and relevant to the work that we do. And so I want to share with you in today's discussion some of the key takeaways and teaching points of this particular case. And also I want to take this opportunity to share with you some of what you may not know regarding cases in general and how cases are handled and how cases progress through the hierarchy of authority in the workers' compensation system. So we're going to kill several birds with the same stone in today's discussion. And we're going to certainly spend some time on the final conclusions of this particular decision so that you can reinforce some of what you already know. And what you already know I'm referring to in this particular case about your apportionment approximate percentages. So this case heavily involves apportionment, and there are teaching principles for us as qualified medical evaluators. So with that as our introduction, let's begin today's discussion, and let's just investigate, first of all, some of how these decisions progress to the level or to the point at which they arrive in front of the full 7-member panel of the WCAB to result in an en banc decision. Okay, so let's begin today's discussion by learning what exactly is an en banc decision. Well, the term en banc is a French term, it means in bench or as a full bench. And so therefore, in the legal context, it refers to a case that is heard before all the judges of a court, rather than by a panel selected from them, from the group of all the judges. Now, in the WCAB here in the state of California, there are 7 judges that sit on the WCAB. And you've heard in the past of what are referred to as panel decisions. Panel decisions is a small subsection of the judges of the WCAB. And typically, panels are made up of 3 of those judges, a rotating group of 3 of those 7-member judges of the WCAB. So in an en banc decision, all 7 judges, referred to as commissioners, all 7 commissioners of the WCAB get together to deliberate and decide on any particular issue. Now, the primary purpose of an en banc decision is to maintain uniformity in the court's decisions or to address particularly significant legal issues. And I would say that that's rather than an or, it's an and. Most of these en banc decisions address particularly significant issues with the purpose of establishing uniformity in the court's decisions from that point moving on forward. And so this is here where you see that the outcomes of these particular case decisions become binding precedent on all the judges and all the courts throughout the entire state of California, such that uniformity of decision making can be established and can be maintained throughout all of the courts. And in the context of workers' compensation cases in the state of California, an en banc decision would be one issued by all 7 commissioners of the Workers' Compensation Appeals Board. So they all get together, rather than a panel of 3, all 7 get together and decide the issue, determine the outcome and conclusion of the issue, and then that outcome and conclusion becomes binding precedent on all the judges, all the workers' compensation judges, and all of the courts throughout the state of California. So here it tells us that the WCAB is a 7-member judicial body appointed by the governor and confirmed by the Senate that hears and determines appeals from decisions by workers' compensation administrative law judges. So let's just stop right here. So in the workers' compensation system, the first level of authority of decision making rests with the workers' compensation judges. Now, you'd be surprised to find out, but not in every single case. In fact, in very many cases, the decisions of the workers' compensation administrative law judges are appealed, are asked to be reconsidered. And the matter then escalates to the next level of authority, which then becomes the WCAB. So the WCAB will take the matter and will issue the matter to a panel of commissioners. And as I said earlier, a panel of commissioners consists of 3 judges. And then the 3 judges will address the issue, will address the appeal, and will render an opinion. And this opinion is referred to as a panel decision. Well, with an en banc decision, the issue escalates beyond the panel up to all 7 commissioners of the WCAB who render a decision, and those decisions then become binding on all WCAB judges and represent the final and definitive interpretation of California workers' compensation law on the particular issue that they are addressing in this particular situation, circumstance, or in this particular case. And the reason that there's quite a bit of buzz now about this current en banc decision, and actually about any en banc decision that comes down through the WCAB, is that an en banc decision by the WCAB in California is a fairly rare occurrence. And it typically indicates a particularly significant or controversial legal issue. And I'm going to share with you in today's discussion what was the significant and controversial legal issue that is involved in this case. If a panel decision contains a significant policy issue that merits a uniform statewide decision, the appeals board might grant reconsideration on its own motion to decide the matter en banc. And that's what happened in this particular case. This case came to the WCAB on appeal as the defendant, as we're going to see, appealed the decision of the workers' compensation judge. So the matter then came to the WCAB, and the WCAB commissioner, the head chief commissioner, in reviewing the matter, decided to bring the matter in front of the whole group for an whole group en banc decision. Now, it's important to note that, like other court decisions, these en banc decisions can be appealed even to the next higher level of authority, which would be the Court of Appeals. Okay, so the hierarchy of authority begins with the workers' compensation judge, which then proceeds to the WCAB through the use of a panel, a 3-commissioner panel. En banc decisions involve all 7 commissioners of the WCAB, but even those decisions can be escalated to the Court of Appeals, and even beyond that to the Supreme Court of California. And we have cases that we deal with in workers' compensation that are Court of Appeals decisions. We even have Supreme Court decisions that then themselves go on to create binding precedent on the particular legal issues that they address. Now, en banc decisions are not the final word on the matter, but they carry considerable weight and are highly influential in the interpretation and application of workers' compensation laws here in the state of California. So let's trace this flow through the courts. Let's trace the flow of decision making through the courts on a hypothetical situation that involves, for example, an examinee who claims an industrial injury, and that injury then becomes denied as a denied claim. Let's follow some of the sequences of events of that particular scenario that could bring the matter up to the WCAB. So let's imagine a hypothetical scenario where a dispute could progress throughout the levels of authority to end up at the point in its life cycle where it becomes addressed by all 7 commissioners of the WCAB for an en banc decision. So imagine an injured employee who files a claim for a work-related injury, and that claim then becomes a denied claim by the claims administrator. So in this particular scenario, the employer's insurance company will investigate the claim, which may include reviewing medical records, conducting interviews, etc. And following the investigation, which can last up to 90 days, as you know, the insurance company will decide whether to accept or to deny the claim. Okay, you're all familiar with this process. Now, if the insurance company denies the claim, of course, this is an adverse decision to the employee. The injured worker employee can then appeal this decision. Now, the first level of authority is with the Workers' Compensation Administrative Law Judge. So this appeal is initially heard by the Workers' Compensation Administrative Law Judge. Now, if the Administrative Law Judge renders an opinion, and that opinion is again adverse to the employee can then ask the commissioners of the WCAB to review the matter, and this is the second level of appeal. First level of appeal brought the matter to the Workers' Compensation Law Judge. Now here, the judge has issued his decision, and either party, any of the parties, whether it be the claims administrator or the injured employee, can appeal to the commissioners of the WCAB. Now, this is where the WCAB creates a panel. A panel of 3 judges will hear the matter. So the WCAB panel will review the decision made by the Administrative Law Judge. This is done by a panel of 3 commissioners, and by majority rule. In other words, they don't have to rule unanimously, but in a 2 out of 3 vote, the panel will either affirm, will amend, or will rescind the decision by the Workers' Compensation Administrative Law Judge. Okay? Now, between these 2 steps here, the judge will write up a report giving his recommendation as to how this group should handle the matter. In other words, the workers' compensation judge will provide a summary of his or her findings, his or her decision-making process, and provide that to the WCAB, and then the WCAB will use that information in determining whether to hear the matter or whether to not hear the matter. Now, if the case raises significant legal issues, as in all of these en banc decisions, and as we're going to see today, there are significant legal issues involved, the full WCAB, all 7 commissioners, may decide to review it together and issue an en banc decision. This involves a new hearing before the full WCAB, after which the WCAB will issue its en banc decision. And again, this is a very rare occurrence, but when it occurs, it establishes a binding precedent throughout all of the courts throughout the entire state of California. So it's quite a big deal. So the hierarchy of authority in California workers' compensation first begins with the panel decisions. And panel decisions are very, very interesting. Most of the decisions that you'll read are panel decisions. And panel decisions are decisions that are reviewed by 3 of the 7 commissioners of the WCAB. And panel decisions can be decided on a majority vote of the panel. So if 2 of the 3 members vote similarly, then the issue is decided along the lines of their decision, of the majority's decision-making process. Now, these cases are very interesting because in those cases where one commissioner does not agree with the other 2, the other commissioner's opinion becomes what's known as the dissenting opinion. And many times these dissenting opinions are very, very illustrative, very, very educational because they provide an opposite perspective to the majority's perspective. So these provide great learning opportunities for us as qualified medical evaluators to hear multiple sides of the same issue. So I encourage you to read as many panel decisions as you can get your hands on because they will educate you greatly as a qualified medical evaluator. Now, the next level of authority is a significant panel decision. We'll put the word significant here in quotation marks because a significant panel decision is a higher level of decision. It's a decision of more importance to the general overall community. It's a decision that then becomes disseminated and published, but not to the same level of authority as an en banc decision, where an en banc decision becomes binding precedent throughout the state of California. Okay, so let's take a look at some of the definitions of each of these particular decisions. So first of all, panel decisions, we have panel decisions. And panel decisions are not binding precedent on other appeals board panels or on workers' compensation judges, but panel decisions are citable and are considered to the extent that their reasoning is persuasive or to the extent that their reasoning is applicable to any particular case that's now being deliberated on by the workers' compensation judges or even on the panels. So these decisions are citable, and you can cite these in the body of your reports as well. You can say things such as, similar to Cannon versus City of Sacramento, or you can say things such as Kite versus East Bay Municipal Utility District. In other words, you can also cite these cases in your reports when you have circumstances in your evaluation that are analogous to some of the circumstances or situations involved in these panel decision cases. And the parties will consider your citation to the extent that your reasoning is relevant and to the extent that your reasoning is persuasive, to the extent that your reasoning is analogous in your case to the particular case that you're citing, that will be considered by the judges and the panels should your case escalate through the levels of authority. Next, we have the significant panel decisions. These are, emphasis is on the word significant panel decisions. These are decisions that have been reviewed by each of the commissioners, all 7 of the commissioners, who agree that the decision merits general dissemination, general distribution throughout the system. Significant panel decisions specifically are intended to augment the body of binding published appellate court opinions and en banc decisions issued by the full board. A panel decision is not deemed a significant panel decision unless, number one, it entails an issue of general interest, especially a new issue or a recurring issue about which there is little or no published case law. Number two, all WCAB members review the decision and agree that it is indeed a significant decision. And number three, that the board takes care to ensure that the decision is thoroughly deliberated and carefully researched. So significant panel decisions are decided upon by all the members of the board. They all must agree that this represents a new or recurring issue that must be distributed throughout the workers' compensation community. And then finally, we have the en banc decisions. And these en banc decisions, again, are reviewed by all 7 commissioners of the WCAB. So if the case raises significant legal issues, the full WCAB, which refers to all 7 commissioners, may decide to review it together as a group, and this involves a new hearing before all 7 commissioners, after which the WCAB issues its en banc decision. And again, these decisions are binding precedent on all appeals board panels and on all workers' compensation administrative law judges, and they basically establish a new modus operandi, a new precedent of decision making throughout all of the courts, beginning with the workers' compensation judges and then all the way up to the appeals board and the panels. And this becomes the new precedent or the new rule or the new law of the land. So let's see now that we understand about how these decisions progress up in authority through our court system, let's see how this becomes relevant for the particular case that just came down just last week, Nunes versus the Department of Motor Vehicles. And with Nunes versus the Department of Motor Vehicles, we can now add that case to this list of other en banc decisions that you may be familiar with. I know you're all familiar with the case, the Alvarez and Guzman case. You're probably all familiar with Escobedo. You're probably all familiar with the Benson case. All of these cases are well-known cases to us because they represent en banc decisions of the WCAB. Other cases that you may have heard of, but probably not as familiar with, but that also are en banc decisions, are the Wilson case, which has to deal with catastrophic injury as that's defined for psychologic injury, and the Suwan and Navarro cases, which really don't relate to qualified medical evaluators, except that these particular cases establish some binding precedent as to how documents and records are to be provided to us as qualified medical evaluators. And you can imagine, with all of the parties involved in these cases, the providing of documents and records and non-medical records to qualified medical evaluators is a big and important deal, and these cases help to establish some of the binding precedent that describes how that process is to transpire. So we now have a new case today, which is Nunes versus the Department of Motor Vehicles, that we're going to be considering in our wealth of knowledge regarding en banc decisions. So let's see what happened in this particular case. Now, as I said at the beginning of our discussion today, this case has probably only tangential application to us as qualified medical evaluators, but it does contain several teaching principles, and it's going to refresh our understanding of some principles related to apportionment. So I believe there are gold nuggets and kernels of education here in this case for us. So in this particular case, Nunes worked for the Department of Motor Vehicles, and she made a claim. She made a claim for 2 circumstances or incidences of industrial injury. One was a specific injury, and one was an allegation of cumulative trauma injury. Well, after all the dust settled out Ms. Nunes was provided a permanent impairment rating of 100% total disability, 100% permanent disability. And the judge provided that award unapportioned. So Ms. Nunes was on the verge of receiving an unapportioned award for 100% total and permanent disability. But of course, in an act of desperation, the defendant sought reconsideration of this award by the workers' compensation judge. And you can imagine the cost of a 100% unapportioned award of industrial disability. So as you can see, both the level of permanent disability and the apportionment of that permanent disability are going to become the operative disputes and issues that bring this particular decision up through the levels of authority to the point where the matter is heard before all 7 commissioners of the WCAB. Well, in this particular case, the qualified medical evaluator, and there was, I believe, only one qualified medical evaluator. Qualified medical evaluator provided impairment for the cervical spine, for the left upper extremity, which I believe was the shoulder, and then also for carpal tunnel syndrome. And the qualified medical evaluator, in doing a good job, she provided a separate apportionment opinion for each of the individual impairments. So for the left shoulder, she opined that the impairment for the left shoulder was 100% industrial. For the cervical spine, she opined that 60% of the impairment was industrial, with 40% being due to other factors. For the carpal tunnel syndrome, her percentages reversed. She opined that 40% of the impairment was industrial, where 60% was due to non-industrial factors. So we have some sort of across the board here opinions on apportionment. Well, you'll notice that with a cervical spine impairment and the carpal tunnel syndrome impairment here, the qualified medical evaluator provided some apportionment for these particular impairments. So then how was it then that the judge provided an unapportioned award? When the qualified medical evaluator is opining for apportionment, how is it that we come to the point where the judge provides an unapportioned award? How could that be? Well, we're going to see how that came down here in just a couple moments. So the workers' compensation judge, he prepared a report and recommendation recommending that the applicant's permanent and total disability arose solely, meaning 100%, from the specific injury of 2011, and that was this particular injury right here. So 100% total disability, 100% due to the industrial injury with no other factors involved, even though the qualified medical evaluator here provided what was otherwise considered to be valid legal apportionment. So how was it then that the judge arose at this particular determination? Well, the judge arose at that particular determination on the advice and recommendation of the vocational experts that were involved in the case. And the vocational experts, there was 2 of them. There was an applicant's vocational expert and there was a defense vocational expert. And at least speaking for the applicant vocational expert, the applicant's vocational expert took citations from the QME's reports, wherein the QME reported that the collection or constellation of Ms. Nunes's disabilities rendered her unable to compete in the open labor market, rendered her unamenable, meaning not eligible for vocational rehabilitation. Well, the vocational experts concurred that Ms. Nunes was unable to return to the competitive labor market. So if she was unable to return to the competitive labor market, she was therefore 100% disabled because she had lost 100% of her future earning capacity. Okay, so this is an important nuance for us to understand. It was not the qualified medical evaluator that provided a permanent total disability rating of 100% disability. Qualified medical evaluator had a much lower impairment or disability rating. But because the combination of those disabilities rendered Ms. Nunes unable to participate in vocational rehabilitation and rendered her unable to return to any type of gainful employment, she had a 100% loss of earning capacity, and therefore she had a 100% permanent disability rating on the information provided by the vocational experts. So this is where the vocational experts' opinion exceeded and superseded the opinion of the qualified medical evaluator, even though, in fact, the qualified medical evaluator did agree that Ms. Nunes was unable to return to the labor market. Well, this 100% disability rating, of course, 100% apportioned to the industrial injury, of course, rubbed the defendant wrong, rubbed the defendant as being inaccurate, because remember that the employer is responsible only for the percentage of the disability directly due to the industrial injury. Well, in this case, that percentage due by the employer was determined by the vocational experts to be 100%, whereas if the qualified medical evaluator's opinion was followed, that portion would be significantly lower, and this caused the defendant to object or to demand a reconsideration. Well, this came to the WCAB. The commissioner rose it and presented it to the entire 7-commission panel, and the 7-commission panel deliberated on the issue, and I'm going to share with you some of the conclusions that they arrived at in their en banc decision. And this is a good review for us as qualified medical evaluators to review our understanding of some of these principles related to apportionment. So remember that Labor Code Section 4663 requires a reporting physician to make an apportionment determination, and 4663 prescribes the standard for apportionment. You're all familiar with the language of 4663. If you're not, you should be. You should be nearly fluent in the language of 4663. It's short and it's easily memorizable. However, 4663 makes no statutory provision for vocational apportionment. And in this case, the vocational experts opined that 100% of the loss of earning capacity was due to the industrial injury, because it was the industrial injury that rendered Ms. Nunes unable to return to the open labor market. Remember, before the industrial injury, Ms. Nunes had other factors in her cervical spine going on. She had other factors contributing to her carpal tunnel syndrome. She had other factors. Everybody agrees that she had other factors. However, before the industrial injury, those other factors were not contributing to her complete loss of earning capacity. In fact, she had no loss of earning capacity, even in the context of other factors. So this is the concept of vocational apportionment as distinguished from medical apportionment. So the WCAB 7-member panel of commissioners reminds us that the Labor Code makes no provision for vocational apportionment. They reminded us that vocational evidence may be used to address issues relative to the determination of permanent disability. And in this case, the vocational evidence did provide a conclusion that Ms. Nunes was 100% permanently disabled. So in that sense, the vocational evidence was critical. But the vocational evidence must address apportionment and may not substitute impermissible vocational apportionment in place of otherwise valid medical apportionment. So this is where the workers' compensation judge became confused and substituted vocational apportionment, where the vocational experts opined that 100% of the permanent total disability was due to the industrial injury. In fact, it was a September 2021 or September 2011 industrial injury, and 0% was due to other factors. That decision, that reliance on vocational apportionment, neglected the qualified medical evaluator's valid medical apportionment. So this was then heard by the 7-member panel of commissioners of the WCAB, and this herein is the final decision of the en banc decision of the WCAB. This now going to go on to become binding precedent on all workers' compensation judges, all panels, and throughout the entirety of the WCAB. This is the take-home decision. And I'm going to provide a copy of this case for you in conjunction with today's discussion so that you can read this case for yourself. But here is what's relevant for us as qualified medical evaluators, is that Labor Code Section 4663 requires a reporting physician, and that's you and I, requires by law to make an apportionment determination. And that apportionment determination consists of 2 opinions. Number 1, our opinion of the approximate percentage of the impairment or disability that's a direct result of the industrial injury. And number 2, an approximate percentage of the final impairment or disability that's due to other factors. The purpose of this determination is to tell the claims payer or the employer how much of that disability the employer is directly liable for, okay? And Labor Code Section 4663 prescribes the standard for apportionment. But 4663 does not make any statutory provision for quote-unquote vocational apportionment. In other words, medical apportionment cannot be neglected in favor of a concept referred to as vocational apportionment, which is what happened initially by the workers' compensation judge, in this case, Nunes versus DMV. Now, on the other hand, vocational evidence may be used to address issues relevant to the determination of permanent disability. And you're going to see this in the cover letters that you get as qualified medical evaluators. The attorneys, particularly the applicant attorney, will ask you, do you suggest that the examinee be evaluated by a vocational expert for return to work issues? And what they're asking is whether or not you believe that a vocational expert should consider the capacity of the examinee to return to either the same employment, to gainful employment, or whether the examinee cannot return to gainful employment at all. Finally, vocational evidence must address apportionment. And here they're talking about must address medical apportionment that's provided by us as the qualified medical evaluators. And the vocational experts may not substitute an impermissible, means not allowed, vocational apportionment in place of otherwise valid medical apportionment. And that's what happened in this case. The qualified medical evaluator provided an apportionment determination that was that constituted substantial medical evidence, and therefore it was determined to constitute valid medical apportionment. So she did her job as the qualified medical evaluator. But the vocational experts substituted their idea of what they referred to as vocational apportionment, And that became relied upon by the workers' compensation judge in providing Ms. Nunes with the 100 and 100 determination, where she was determined to be 100% permanent total disabled on the evidence provided by the vocational experts, with an unapportioned award 100% due to the industrial injury, again on the basis of the vocational expert's opinion. And what we're going to see is that this opinion, the vocational evidence that contributes to the 100% permanent total disability conclusion, can remain, because vocational evidence may be used to address issues relevant to the determination of permanent disability, but it's this apportionment percentage that is now going to be denied, declined, rescinded, and returned back to the court level for further development of the record and further development of what should be the apportionment of this 100% permanent disability award. So doctors, what do we make of this, and what do we think of this, and how does this relate to us as qualified medical evaluators? You know, we don't often have a lot of interaction or exposure to vocational experts and vocational evidence, but behind the scenes, it's important that we take seriously our own apportionment determinations, because our apportionment determinations are used in many ways throughout the system, and this particular case highlights one of those uses. One of the uses of our apportionment approximate percentages has to deal with how those apportionment percentages are interpreted by the vocational experts, and how our percentages are used by the vocational experts in rendering their opinions and providing their vocational evidence that then goes on to contribute to a resolution of the case or cases. So doctors, I hope this helps you. I hope this re-inspires and reinvigorates you to pay particular attention to the opinions and conclusions that you offer in each and every one of your reports, and especially your apportionment approximate percentages, because your apportionment approximate percentages, when they constitute substantial medical evidence, are used in many of the down the line decisions that we don't even get involved with, and that we may or may not even be aware of, but upon which the parties rest and rely in bringing these cases to a successful resolution. So I hope that helps you. I hope that served as an educational opportunity for you today. I want to thank you for taking the time to join me on today's discussion. And for now, this is Dr. Perry Carpenter. I'm wishing you best of success in your career as a qualified medical evaluator.